right. Well, welcome to the Mountain States Legal Foundation April webinar in the So a Neighbor Asked series. Today, we're going to be talking about the Second Amendment. We have some incredible guests with us here today who will introduce, and then we're going to jump right into it. There is a Q&A box on your window right now. So if you have a question for our guest today, go ahead, drop it in the Q&A box. We'll definitely have time toward the end of the session to get to those questions and hopefully answer all of them. With that, let's introduce our guest here today. With us on the screen is Mike McCoy, who just joined us in the last few weeks as the director of the Center to Keep and Bear Arms. We're happy to have Mike aboard, and we'll have him introduce himself and his background a little bit more in a second. We have Sean Nation, our Deputy General Counsel here at Mountain States Legal Foundation. Sean's been with us doing a lot of Second Amendment work over the last year and has been lead counsel in our 3-day waiting period case. And we have an honored guest here, the Executive Director of the Rocky Mountain Gun Owners, Taylor Rhodes. Taylor, I want you to introduce yourself a little bit more as well, because you have an incredible background as partly a lobbyist, now an advocate, and the Executive Director. So I think it's interesting for our guests to hear that. Right. Why don't you go ahead?
Sure. So I jokingly say that before I started in nonprofit politics, I was a campaign hack. I literally worked on campaigns, literally dog catcher races. That is a thing in the state of Mississippi. You can run for animal control all the way up to president of the United States, where I helped Ted Cruz and Carly Fiorina in 2016, and then the Donald Trump campaign in 2016 later on that year. I started with Rocky Mountain Gun Owners in the fall of 2018, after I made my way to Colorado as a consultant for the RNC and then working for a governor's campaign out here. I loved it, met my wife here. I never looked back, started as a contract lobbyist in 2018, and then worked my way up directing our super PAC, and now I run the organization on a day-to-day basis.
Incredible. Well, Mike, why don't we have you introduce yourself as well, and then talk about your background as the new Senator to Keep and Bear Arms Director.
Yeah, thanks, Will. Mike McCoy, Will said. I actually joined the center with almost 25 years of experience, not in the civil world, but in the criminal world. I've been a prosecutor for my entire professional career. I started off as a JAG in the United States Air Force. I was active duty for 6 years, spent one of those years in Iraq working on the Saddam Hussein trials, which was a super interesting experience. And then I went to the U.S. Attorney's Office, first in Illinois in the Central District, and then to the Eastern District in California. And then I finished off my career as a prosecutor as a Deputy District Attorney in El Dorado County here in California, which is where I'm currently talking to you from. This is where I live with my family. And I've been in California for my entire life, other than my military service. It's obviously a target-rich environment when it comes to challenging some of the ridiculous gun statutes that are on the books out here. But nevertheless, I'm happy to be with Mountain States very much. Will said something last week during a meeting that kind of summarizes how I feel about it, because he was trying to summarize what we do as attorneys with Mountain States. And he said it succinctly and perfectly by saying we litigate on behalf of the Constitution of the United States. And that's what we're doing, right? We're fighting for the Constitution. And so to be part of that fight really is quite an honor. So thank you for having me.
Perfect. Well, actually, you lead me to my first question, which I want to just open up to the floor here. You know, we had this incredible decision called Bruin in 2022, and you could be forgiven for thinking that things were going to get better and that the efforts at attacking the Second Amendment would slowly die away, but just the opposite has happened. We've seen these ramp up. Taylor, why don't we start with you? What are you thinking in terms of the current landscape, the biggest threats to the Second Amendment, and the right to self-defense?
Right. So interestingly enough, Rocky Mountain Gun Owners had the first post-Bruin lawsuit filed right here in Colorado in the little town of Superior, where we thought the silver bullet was going to be the silver bullet. An Obama-appointed judge ruled in our favor on a temporary restraining order, which inevitably turned into long and short of not a preliminary injunction, but a preliminary injunction, where they used the Bruin decision, saying on the back of the Heller decision, saying that you can't do this. It doesn't meet the text, history, or tradition. And yes, AR-15 style rifles are in common use. In fact, there's 3 times as many AR-15s as Ford F-150s, the most commonly driven truck on the road today. So after Bruin, what, 2 years ago now, almost 2 years ago now, we're sitting here saying, okay, well, what do we do next? And as we've partnered with Mountain State on our 3-day waiting period, we're litigating not just with Mountain State, but on our own on assault weapons bans and so-called ghost gun bans and a litany of anti-Second Amendment legislation that's passed here in Colorado. But our national organization has really taken the task of fighting against assault weapons bans around the country. And one of those may actually end up in the Supreme Court. We've just gotten cert on that, or just filed for cert on that, excuse me, in the last few weeks. So the way the Bruin decision actually works is still kind of yet to be seen.
Yes, Sean, go ahead.
Well, and at this current term of the Supreme Court, there's a case called United States v. Rahimi, where the government very clearly and deliberately chose really bad facts to try to limit the reach of the Bruin decision. That should be coming out before the end of the term, and we'll see what they have to say. Remain hopeful that they'll reaffirm the Bruin decision and still say that, this guy was a real bad guy who probably shouldn't be allowed to have firearms. In addition to that, we at Mountain States recently were granted certiorari cert in a case called Vanderstock involving the ATF's attempt to redefine what a weapon is, what a firearm is. Essentially, the ATF thinks a tree is a firearm if you take the rule to its logical conclusion. So we're happy to challenge that. It'll be heard in the October term. So later in this year, most likely, possibly early next year, and we should have a decision on that by the summer of next year.
Well, Mike, you're joining us from California. Not so much the land of the free these days. Can you share your perspective? Maybe take a step back in terms of what Bruin is and talk about Bruin, and then also what sort of threats to the Second Amendment you're seeing on the ground in California.
Sure. I mean, what the Reader's Digest version of Bruin is that the court held that in order for a gun regulation, a statute to be upheld, the government's got to establish a historical analog to that particular regulation, whatever it might be. So, for example, waiting periods. What's the historical analog, or what example in history can the government point back to and say in the past, specifically around the founding of our country, when the Second Amendment was being drafted in the 1790s, what historical analog or historical example do you have for waiting periods? The answer is none, effectively. And you can kind of say that for most of the regulations that are pushed through. I mean, there were prohibited people at that time, and obviously that's a different story, but on 90% of the regulations that both state and federal government is trying to push through, there is no historical analog. The concern that I have, and I think what all of us are seeing, and probably all of you are seeing as well who are watching this, is that the courts, the lower courts, the district courts, are finding every way they can to get around Bruin, including in a case that we just filed an amicus brief on, in which the district court judge, their way around Bruin was by saying history is hard. And I shouldn't, as a judge, have to go back and be a history professor and figure out what the historical analog is. Well, that's ridiculous. Anyone who's been to the first week of law school knows that's the whole point of law, right? You're looking back at precedent. And what is precedent, but what's happened in the past? So we're trained as attorneys to look back in the past. And whether that's in a legal context or a historical context, those two things go hand in hand. So the lower courts are, in a way I've never seen in my entire career, finding ways to basically ignore what the Supreme Court said in Bruin, ignore that precedent, which is unprecedented as far as I'm concerned. And I think that's one of our main concerns and main struggles here in the next few years, is to push back on those lower courts. And hopefully the circuit courts, have much more respect for the precedent that has been set.
Yeah, and you even see it at state Supreme Courts. My favorite, most recent ignorance of Bruin was from the Hawaii State Supreme Court that said, the aloha spirit is fundamentally incompatible with Bruin.
You must be joking that they said that.
A close paraphrase.
They literally
they said that.
The aloha spirit.
Yeah,
aloha spirit.
One of the things that I found interesting, and I can't remember if it was in our 3-day waiting period case or one of our others, The state, the government, is literally using slave law to say, okay, well, this was the law then. Yes, that's the history. Well, those weren't free men at the time. Those were slaves by definition.
Yeah.
The government is looking at us as slaves in modern 2024 and trying to say, well, this was the law then. Well, maybe it should be the law now.
Yeah, it'd be like if I went into court, it was like, this Dred Scott case is terrific for us. We're going to rely on it, right? Those are the sorts of things that you would think would be days of bygone past, but now they're relying on these restrictive anti-gun laws that applied to slaves and other unfavored persons. Taylor, let's keep it with you. We've got 18 to 20-year-old bans, we've got assault weapons bans, we've got waiting periods. Were any of these at all, at the founding, that the government has tried, or at least is coming up with some arguments about how they might be analogized to the founding or the ratification of the Constitution?
So based on my knowledge and research, the answer is simply no. The only gun laws that we can find are drunk with a gun. There's some weird for quality control. Some manufacturers had imposed stamping for quality control. That's not really a law, though the state and the government is always using that as such. The others were slave laws. Basically, everything else actually be the opposite. I think in our 18 to 21-year-old case, I was looking up colonial law of if there was anything required, and actually I found the opposite. In a lot of cases, it was required to own a gun at the age of 15.
Yeah.
Actually, there was one Boston town that required it at the age of 9. So with that said, it doesn't really go in their favor of that text history or tradition.
Yeah, there's an early founding law called the Militia Act. The founders were very skeptical of standing armies. So they didn't keep a standing army, but they required every free adult male to be a member of the militia and to own a rifle or a musket with sufficient powder and shot, should the need arise. So, it's the same way. You are required at the founding, if you are 18 and above,
right,
to possess a firearm.
As long as we're talking about history, sorry, Will,
go ahead.
One of the things to point out is, the Revolutionary War did not start on July 4th of 1776. It started in April of 1775. Perhaps earlier than that, but certainly that with the battles of Lexington and Concord and the shot heard around the world, that wasn't fired by a state National Guardsman or a member of the United States Army. There was no army at that period of time. There was no Continental Army. The opening battles of the war were fought by civilians with guns, right? That they had in their possession. And they were the ones who, in Lexington and Concord, that was a victory for us. We defeated the British. We caused them to run back to Boston. And even Bunker Hill and Breeds Hill, which were technically losses for us, were victories in the sense that we killed off 1/4 or caused casualties to 1/4 of the British military force stationed in North America at that period of time, outside of Boston. And so these were victories at the hands of civilians with guns. And that's what was in the minds of the founders at the time that they're writing the Second Amendment, is that there may come a time in the future, not just on personal self-defense, but on defense from a tyranny. They had just overthrown the tyranny of King George and the British Empire. And they foresaw that it was important that the people have that ability to do that again if need be in the future. So
yeah, and Mike, let's stick with you because you mentioned the Baird case where we filed a brief last week. Yeah. In that case, the district court actually threatened, although she backed off, to appoint like a special master expert witness that would just consult her. So it wouldn't be the plaintiffs or the defendants expert. It would be the judge's expert. And at some level, I thought she was sort of trolling the Supreme Court by saying, "You've given me an impossible task. I can't do it. I need a historian. I'm just a judge." What do you make of that and the trend that a couple of judges now have done that, including in our Sullivan case? Something similar happened. Is that a cop-out? Is that a tactic to undermine Bruin? What's the long-term strategy that you see lower courts playing out here?
I think the lower court's strategy is to undermine Bruin in whichever ways they can. And so that is, again, as I said in my initial comments, it's ridiculous for a lawyer or judge to say that they have no qualifications for applying history to the law. That's ridiculous, because that happens in nearly every case. You have to apply history to the law, whether it's recent history or past history. That's what they're doing. That's what you learn in law school. That's why we have a common law system that's based on precedent, right? Going all the way back to Britain in some cases. And so that is a cop-out, but it's also a strategy too, I believe, for them to undermine Bruin and to basically make it okay for other lower courts to do the same thing. And the question is what are the circuits going to do? And we have, obviously, Barrett is now going in front of the 9th. We have other cases going up in front of the 10th right now that Mountain States is currently involved in, and including Garcia, which is a case that Rocky Mountain Gun Owners Association is involved in. And so the question is the 10th going to do what they're required to do, which is follow the precedent of the Supreme Court, which is pretty clear and direct and not confusing and not hard, contrary to what the judge in Barrett said. So
yeah, and Sean, you mentioned the Hawaii case where this involved the state Supreme Court basically saying that Bruin doesn't apply in Hawaii. It sort of reminded me of the segregationists who wanted to ignore Brown v. Board and say the Constitution doesn't apply here. We have states' rights. What do you make of that? Because that's actually different than saying history is hard. It's saying, no, the Supreme Court doesn't control Hawaii's law.
Yeah, so there's this notion before the Supreme Court of what's called adequate and independent state grounds, which is it's not a federal issue, it's just a state issue. And so in that case, the judges, probably justices, went through Hawaii's history of firearm and weapons regulations from when it was the Kingdom of Hawaii and attempted to say, well, that's our history and it's incompatible with the rest of America's history. I think that's bunk. When you join these United States, you take the history of the entirety of the United States. Recognize that Hawaii does have a unique history as formerly the Kingdom of Hawaii, but that's nice. It can provide perhaps some local color, but at the same time, the Second Amendment applies to Hawaiians as well. They have the right, this case involves the right to carry a firearm, to bear a firearm. And fundamentally, Hawaiians are American citizens, and they have that right.
Yeah, they have a representative, 2 senators, they get votes in the Electoral College. Every indication is they're part of America, obviously. Exactly. So this for the court to say, oh, the Second Amendment doesn't count here is a little absurd. Taylor, do you want to talk about the 3-day waiting period? You mentioned the analogy that courts have tried to draw to not being drunk and carrying or firing a gun. And that's the analogy the district court drew. Right. Obviously, we're up on appeal now challenging that. But here the judge said, well, literally everyone couldn't be drunk and buy a gun. So that's sort of like a waiting period. What's your reaction to that logic?
Well, it's just another, which when we were in the courtroom, we kind of knew what the answer was going to be. I mean, we drew possibly the worst judge that we could have drawn. I mean, the guy's been on the bench for 44 years and was appointed by Jimmy Carter, I think. Yep. And he acts like it, right? We could have known the outcome, and we knew that we were going to appeal, and that's a lot of what we see in these. And frankly, what these judges are doing is a lot of them are becoming activists from the bench, and then they're being struck down in the circuit or potentially maybe in the Supreme Court, and that's why groups like us and Mountain State and others exist right now, is to make sure we're taking the fight to them and that we keep it progressing so that we can get the ruling that is constitutional.
Let's talk about Vanderstock, which is the case Sean just mentioned a second ago. So this is a case where the ATF issued a rule expanding its own authority to regulate what is or is not a firearm. So they expanded it to cover these home hobby kits and said that those things now have to be regulated by the ATF. We challenged that rule in the district court and won, challenged that rule in the appellate court and won. Then the government appealed to the Supreme Court. And now the case is going to the Supreme Court. Sean, talk to us a little bit about what happens next now that we're in the Supreme Court and what that case is going to be about going forward.
Sure. So procedurally, we'll get a scheduling order, essentially. We'll determine when will the government file its opening brief. We'll file a responsive brief. They'll get a reply. Other groups can be what are called amicus curiae. friends of the court brief if they have something that they think is interesting that the court should consider. And then at some point, we'll be scheduled for oral argument, and then the justices will take it under advisement and issue an opinion. The case really is about lower receivers. So in a firearm, the only part that is defined as a firearm is the bit in the middle where the trigger and the magazine attaches, for lack of, to oversimplify things. That's the part that requires a serial number. And what the anti-Second Amendment groups like to call ghost guns are essentially 80% lower receivers. So they've been milled out to be 80% of a firearm, but not a firearm. You cannot put a trigger in it. You cannot attach a magazine to it. You can't put a barrel on it. I mean, I guess you could, but it wouldn't do anything. It is functionally a paperweight until you go to your press or your router and you take away little bits of metal to finish it off. Why would you do that? Well, because it's kind of fun. People who are into firearms, some of us, we geek out over these kinds of things, whether you're doing an 80% receiver, which candidly I've never done, or building an AR, which I have. And you can make it the way you want it. It's custom to you. There's essentially no evidence that they've ever been used in any crime, but it's one of the bogeyman to the anti-gun groups. So they keep trying to expand authority. Well, the Gun Control Act of 1968 gives the ATF the authority to regulate firearms, and that is a defined term. So what did ATF do? They said, well, we found some ambiguity, so we're going to redefine it the way we want to be able to redefine it. That is a common practice that's done by federal agencies that, knock on wood, will be ended this term. It's under a regime known as the Chevron case, Chevron deference. But there's a case up now called Loper Bright involving herring fishermen in New England that's challenging that doctrine. And we're cautiously optimistic we'll at least limit or narrow it. And then that will, of course, have impacts on how we write our brief and and how the government reacts as well.
Excellent. Mike, let's turn it back to you. Having a gun is a fundamental part of self-defense. We just saw this gentleman in Arizona have a hung jury after he used a gun in self-defense against an illegal immigrant. Talk a little about the use of guns in self-defense and how that right's under attack, and what you're seeing from your criminal background in terms of these prosecutions that keep happening with Kyle Rittenhouse. Maybe I'll include Daniel Penny, where people are using, they're engaging in self-defense and then getting prosecuted for it.
Well, I think kind of from the 3,000-foot view, I think the anti-gun groups, what they want to do through these prosecutions is scare people away from even thinking about using a firearm for self-defense, which is, when we think about it, that's the primary reason anyone owns a firearm, right? Is to protect yourself and your family. You have an obligation to do that, and you have a right to do it under the Constitution. They don't think, and the anti-gun groups don't think any of us should have guns, no matter what we're using them for, including as an honorable thing is protecting your family with it, or yourself, quite frankly. So when you look at like the Arizona rancher case, obviously I was not involved in that case at all as a prosecutor, but looking at the evidence from what I can see, is that's to me a clear example of self-defense. This man had watched over years now, but particularly the last 2 years, an endless stream of illegal immigrants, many of them with cartel connections, streaming across his property. And he got to a point the day that this happened, from what I've read in the evidence, is that he saw groups of men coming across, some of them armed. He fired warning shots in the air. They didn't respond. They continued to come across his property, and eventually fired a round. Although there's questions, the defense raised the issue that they never found the bullet that was the round that was used. But that's a separate issue. I won't go into the different defense strategies that they use. The point is that he used self-defense, which he had a right to do, as did Kyle Rittenhouse. Anyone who watched that video with Kyle Rittenhouse, anyone who watched that would say that was a lawful use of force. And that's what we do as prosecutors. We look to see, was this a reasonable response to the threat that the individual was facing at the time? Now, obviously, if someone's coming forward with you to punch you in the face, generally speaking, you can't pull out a gun and shoot them in the head. However, you can if they're much bigger than you, or you think you're about to face serious bodily injury or death. And so I don't want to turn this into a law exam answer for you, but in all of those cases, there was a reasonable use of force in order to defend themselves, whether it's the rancher and his wife, whether it's Kyle Rittenhouse, or a recent case in Los Angeles, where a guy comes home and sees that there's 3 men, armed men, entering his property. And he actually brandishes his weapon. He doesn't fire the weapon. Nevertheless, he lost his concealed carry permit for a period of time, which is ridiculous because, of course, again, how dare you use your weapon to defend yourself or your family in a legitimate case? Even the crazy prosecutor in Los Angeles wouldn't even think about bringing charges against this guy, and yet he had lost his CCW for a period of time. So there's this effort to whittle down the Second Amendment on every single front, and that is happening now at a level I've never seen in my lifetime. I'm sure Taylor's hasn't seen in his, or will in yours, or Sean, or whoever, fill in the blank. It is this full frontal press on every angle, and one of them comes down to criminal prosecutions, and that's being used for no other reason to scare people. Because who wants to face potential criminal charges, the loss of their freedom, their liberty, for simply possessing a firearm and using it appropriately in those types of contexts? And so
you made a good point of knowing the laws in your state. When you talk about brandishing in Colorado, all I have to do to brandish is open my jacket and show you I have a gun.
Yeah.
I believe that's the law here. That is technically brandishing. You don't even have to pull it out of the holster.
That's right.
Out of the holster, it's now aggravated assault.
What if you're not wearing a jacket?
Yeah, exactly. Exactly. What about the guy open carrying, right? There's a bunch of what ifs. In the case of Kyle Rittenhouse, which I know very closely, Kyle's a friend, and we were actually, our national organization was actually one of the only organization to come to his legal defense. And in that situation, which was clearly self-defense, I mean, still to this day, the kid can't go check into a hotel without, I mean, he's been banned from staying at certain hotels just because of his name.
Wow.
And it's quite sad that even, several years later, after the summer of violence, that even though he is a free man, found innocent by a group of his peers, that he's still facing the repercussions of that.
Well, let's stay with you, Taylor. Speaking of whittling away the Second Amendment, here in our home state of Colorado, we've got a very active legislature. They have complete control over the House and the Senate and the governorship, as they do in California. What are you seeing? You're a former lobbyist. You spend a lot of time at the Capitol. What are you seeing in terms of the the pending bills currently in Colorado and their chances of actually getting enacted?
Right. So there's been a handful that have already been sent to the governor's desk. The big Mac Daddy of them all is no question the assault weapons ban. It is stalled in the Senate State Affairs Committee. It hasn't been given a date, knock on wood. Hopefully it won't. But we only have 8 days left. We're constitutionally required to stay under 120 days. They could gavel in for one day. Good luck. They're never going to do that. They could gavel in for one day, gavel out day 2, and go home. I wish they would. They're not going to. So we've got 8 days left. They're going to use every second of all 8 days. The firearm liability insurance bill, which would require you to carry a type of liability insurance similar to a homeowner's insurance. San Jose, California, tried to do something like this. We sued them and they backed off. Other bills that are increasing the requirement for concealed carry, that you have to take an 8-hour class, shoot live rounds downrange. But permitting for gun shops, which is literally going to give gun shops, make them require them to do mental evaluations and background checks on all their employees, including the owners themselves, going much further than the requirements that the ATF has in store. And that gun shop permitting requirement is because they've now given $1.5 million, give or take, to CBI to enforce the waiting periods and background checks and magazine bans and ghost gun bans, so-called. But that's only on top of this merchant code bill. And I could spend all day talking about this. There's just so many, and I'll shut up after this. But this merchant code bill, let's say you go to Triple J Armory to buy a Glock 19. Now that Glock 19 is going to show up as a merchant code. They're going to have one for firearms, accessories, and ammunition. So that that I call it the CBI Gestapo because that's really what it is. That CBI Gestapo can say, well, Taylor Rhodes just bought a Glock 19 and 5,000 rounds of ammunition. That guy's crazy. We've seen him on the news. We need to go check out what that guy's doing because it can't be good. So we're fighting back, not just in the legislature, but now we're planning to sue on the ones that do pass that we actually have a chance to win over.
Oh, well, the funny thing about the merchant code, when you swipe your card, they don't know what you got. They just know what the code of the store is. So let's say they make Cabela's have, instead of just being general merchandise, it's now a firearm store.
Right.
Well, you go and you buy, $800 worth of camping equipment and it shows up as a firearm because it's not per transaction. They don't know. The processor does not have a way in place of knowing what you purchased, just the category of the store. So it's kind of a bill where they don't know what they were doing. I know that's shocking about state legislatures, but I don't think it's going to accomplish what they're hoping to do anyway.
Right, because as of right now, if you go to any gun shop or Cabela's or Walmart, even still, it's going to show up as sporting goods. It's not going to show up as firearms.
So Taylor, don't shut up. I want to ask you another follow-up question. So Rocky Mountain Gun Owners is known for its aggressive, fighting tooth and nail reputation. Certainly, your work this year and in previous years is justifying that reputation.
Yeah, of course.
What do you say? And I want everyone to comment, but I'll take Taylor, you first. What do you say to people who insist that these are just reasonable gun regulations? A 3-day waiting period is not that bad. A merchant code really doesn't make that much of a difference. A red flag law is only for violent people. What is it that you say when people are like, why do you oppose even the stuff that sounds like it might be just a little incremental as opposed to the big Mac Daddy assault weapons ban?
Right. So this really all started in 1994 under the Brady Bill. The Brady Bill was and is today still the backbone of all of this gun control that we're seeing from 1994 until now. And when the Brady Bill passed, most people were like, okay, yeah, Brady Bill is background checks. Background checks are reasonable. Yeah, we should make sure people aren't crazy when they buy a gun. Okay, great, sure, whatever. I think they're wrong, but I'm going to explain why. When you first put into a background check bill, you don't think about a 3-day waiting period bill, but that background check is the backbone for a waiting period bill. It's all incremental. If, for example, in 2018, when they first ran red flag, it was then passed in 2019. Saying, oh well, this is it. This is going to be the end all do all to end gun violence and make sure crazy people, can be red flagged and they can't do anything. It was, your spouse, your sheriff's department, and immediate family members. Great. Well, what did they do just last year? They expanded that to make it where your child's school teacher can red flag you, your ER nurse can red flag you, your pastor of your church can red flag you. Yeah, because most of them are considered mental health therapists, and they all have that licensing. So your pastor of your church your mental health therapist, your marriage counselor, whoever, basically anyone and everyone can red flag you. So when we talk about, okay, well, this is a common sense move. Okay, it might be, but think 2 or 3 steps ahead because that's what they're thinking, right? When a politician tells you something, what do they have to gain in return? And ultimately, we've seen since 1994, incrementalism has been the game for the left. And they have incrementally eaten away at so many of our rights. And frankly, the large institutional gun rights organizations have bid at it and said, okay, yeah, this makes sense. We're going to compromise. Sure, let's do it. That has eaten away at so many of our rights that states like Colorado and California and Illinois and Maryland that have taken a bite at the initial apple have taken so many bites at the apple. The apple's almost gone.
Sean, go ahead.
I think that's well said. I would caveat that with some of our liberal friends also like firearms. So it's not just the left, it's the anti-gun groups. But I think that's right. It's if you give a mouse a cookie or if you give them an inch, they'll take a mile. So, I certainly understand the fight.
Mike, go ahead.
Yeah, I mean, it is the drip, drip, drip that's now started to be a cascade of anti-gun legislation it's overwhelming. I mean, when you look at, I mean, just joining Mountain States 2 weeks ago, there's so many different options, and Will and I and Sean and I have talked about what do we go after. I mean, that's the problem. I noticed there's a question in the chats too about some like a pistol brace regulations. It's like there's so many things to go after. It's really got to be, what I think one of the considerations we have to have is whether it's big or small, to Taylor's point, everything's worth fighting for. But the bandwidth that we have is only so big. And so you've got to go after the things that are going to set the precedent, right? We look for cases that we think are either there's a split in the circuit, which means that, the Ninth Circuit has ruled one way and the Seventh Circuit, let's say, has ruled the other. We try to force the issue so that ultimately we get a final answer on an issue and shut it down for good, like Bruin should be doing. And it goes all the way up to Supreme Court for that final answer. And so that's the goal, I think, of Mountain States. That's my goal as the director, is to try to find those cases that is really going to have a more macro impact on a lot of different micro gun legislation issues. So.
Yeah, absolutely. So we do have some questions in the chat. Go ahead and drop a question in there. We're going to turn to those in a second. Sean, do you want to say something?
Oh, no, the first question is about updates on the pistol brace litigation. I haven't looked at it in a couple of days, but it's the ATF rule that would turn a pistol brace into make the firearm a short-barreled rifle is currently on hold, pending a decision by the Fifth Circuit. So no major updates yet, but we're reasonably confident that, as in our Vanderstock case, the Andrew case will come out in our favor. Can never fully predict a court, but we are optimistic.
A lot of this litigation is happening in the Fifth Circuit. So our Vanderstock case is there. The Cargill case about the bump stock issue is in the Fifth Circuit. And those are judges who definitely are engaged in these Second Amendment issues and know a lot about guns. Sometimes a judge who doesn't know very much about guns is going to make a lot of mistakes, whereas a judge who actually knows what they're doing can interpret history, can interpret tradition, and get to the right answer. The next question is about the bump stock case. That's a case called Cargill, which is out of the Fifth Circuit. That was argued just a few weeks ago. And the oral argument, it was hard to tell what happened. So some of the justices asked, what's the difference between having a bump stock and having a machine gun? And the answer was, well, even if you can increase the rate of fire with a bump stock, that's not what the statute covers. The statute covers machine guns. So you can't just will your way to banning something that's not covered by congressional statute. So that's definitely a case out there, just like the other cases that we've been talking about. Rahimi, that case will probably have a decision by the end of June. Speaking of Rahimi, Sean, my hope was sort of that the facts of that case were so bad that they wouldn't have to narrow Bruin in order to reach a result there. Do you want to talk about, just how bad those facts are?
Sure. So Mr. Rahimi, I'll try to refrain from characterizing him. He had an incident of domestic violence, probably more than one, where his partner, I believe it was a girlfriend with whom he shared a child, got a restraining order against him, a domestic violence restraining order. And it was an agreed order. So he did not challenge it. He agreed to abide by it, to stay away from her, and crucially, to not own or possess firearms, right? That's in the order that Mr. Rahimi signed. Well, Mr. Rahimi, being of a more criminal nature, continued to batter his partner, and then shot at various people, including inside a Whataburger, when they would not. I believe they got his order wrong or something to that effect. Not a kind of guy that I think most of us would want to have a firearm. So when they finally caught him after he was on the run for a few days, in addition to all of his state charges that he's facing, and he is facing a significant amount of time in Texas prisons, the U.S. Attorney's Office came in and challenged him under under a statute that prohibits people who have domestic violence restraining orders from having guns. They did so, I believe, simply because the facts of the case are so bad, and they were looking for a vehicle to rein in Bruen. At the oral argument for Rahimi, Attorney General Prologer was essentially advocating for them to abandon what they have done in Bruen, or at least seriously limit it. There did not seem to be a majority that wanted to take that approach, but oral arguments only so revealing. So we'll see what they ultimately come down with. I'm sure they will find a way to, I bet they find a way to keep him as a prohibited person, but at the same time reaffirming Bruen.
Yep. Well, that's all the questions we have. Why don't we offer some closing thoughts? Mike, we'll start with you in terms of what you think the CKPA is about to do and where we're going from here. And then we'll take Sean and then close with Taylor.
Yeah, I mean, one, I'm just building off of the comments I just made. You know, we're looking for cases that will have the biggest impact, and not just in that particular area, but obviously because of the precedent that's set will impact legislation, current and future legislation, and hopefully quiet the efforts of local and state governments to push hard on every front when it comes to gun regulations. So that's something we're hoping to do, and what I would like to do. The other thing too is, you know, going back to the discussions we had about the Arizona rancher case or Kyle Rittenhouse, is at some point, you know, I'd love to use my abilities as a prosecutor to defend in criminal court these people who I think are being wrongfully prosecuted for their use of their firearms. You know, I've been a prosecutor, but moving to defense is a natural progression on that front because I understand what is required on the other side probably better than most, and so because of that, I would love to move at that point into that arena as well. So to use the center both from a civil point of view as well as a criminal point of view to really protect and defend our right to bear arms.
Excellent. Sean, what are your high-level closing thoughts about the Second Amendment and the right to bear arms?
You know, it's an exciting space to be in. You know, it's very interesting, very challenging, very dynamic. So, you know, it's good to be on one side or the other, I suppose, but also
just one side.
Yeah, it's to be on the right side, but it's also nice to be able to feel like you're actually protecting Americans' liberty. And you know, that's why I joined Mountain States.
Now, Taylor, tell us your high-level closing thoughts, and then also tell people how they can learn more about Rocky Mountain Gun Owners.
Yeah. So we're in a fight for our lives in Colorado, and couldn't appreciate Mountain State more for jumping in, and really in a time that we just needed another attorney. That's kind of how we got involved with you guys, and really appreciate the work that you guys are doing for us, and we're not going to stop fighting in Colorado, whether it be today, tomorrow, or 10 years from now. I believe, and the rest of our board and my staff and our members believe, Colorado is worth fighting for. And regardless of where you live in the United States, you do have the rights given to you by the Constitution. Well, given to you by God, affirmed by the Constitution, I should say. So with that said, if you'd like to get involved with the fight, I would encourage you to get involved with Mountain State. If you're not already a donor to them, please do. Likewise, join RMGO. Our dues are $35 a year. You can go to rmgo.org to join. We'd love to have you.
Excellent. Well, thank you, gentlemen. It's been a pleasure. And with that, thank you to our audience and all the people who asked questions. We'll see you next month for the next So a Neighbor Asked webinar. With that, we're adjourned.